नमस्कार. आयच्या ह्या खासा डिबेटात तुमकां सगळ्यांक येवकार. तुमकां खबर आहा फाटलें सप्तकभर जालें लुईस बर्जर केसी भितर जशी कोर्टाच्यो सुनावणी जातात त्यो सोंपी भाशे भितर ताजो अर्थ कितें आनी ताजो परिणाम कितें हें आमी गोंयकारां मुखार हाडपाचो प्रयत्न करतात. आज तर चार बेल एप्लिकेशन आशिल्लीं आनीक तातूंतली 2 रिजेक्ट जालीं, एक ग्रांट जाली आनी एकाची ऑर्डर उरल्या. अशे परिस्थिती भितर चर्चिलाची बेल रिजेक्ट जाली, वाच्या सुंदराची बेल रिजेक्ट जाली, मोहांतीक बेल दिल्या आनीक हवाला एजंटाच्या बेलाचेर निर्णय उरला. किती परिणाम हाजो आनी दिगंबर कामतीची जे एंटिसिपेटरी बेल पिटिशन आसा ताजेर ताजो किती परिणाम जातलो हाजेर आमी भासाभास करतात. 2 आदवोगाद आसा परत आनी बरोबर. पयले आसात ते मडगांवचे आनी तांकां साश्टीतले राजकारणय खूब बरें खबर आहा आनी चर्चिलूय बरो खबर आहा आनी दिगंबरूय बरो खबर आहा. ते राधाराव ग्रासियस, स्वागत तुमचें. आनी दुसरे आमचे बरोबर आहा ते फाटले 2 एपिसोड जाले हाजी विस्कटावणी करतात ते क्लिओफा कुतीन, स्वागत तुमचें. Radha, you are new on the panel, so I'll start with you. How are you looking at this rejection of Churchill's bail and Vachasundar's bail, and what are its implications on Digambar's anticipatory bail?
I mean, implications of Digambar's are very clear. It's better that Digambar starts drafting his petition before the High Court if he wishes to. You see, normal course, once Churchill has been rejected bail after 10 or 12 days of custody, it's difficult to imagine that Digambar is entitled for it. So I would think now Digambar should more or less know the fate of his bail application.
What about Vachasundar? Because both of them are in judicial custody. And the argument that was placed today, what are you going to do with them in the judicial custody? They are not even in the police custody.
No, but the fact that they are in judicial custody does not mean you are entitled for bail as a matter of course. You see, the moment your police custody is over, if you were to be released on bail, then there would be no need for judicial custody for under trials.
Correct.
But you see, what happens in matters of bail is there are various factors at work. In this particular case, it is a high profile political case. So everybody is concerned. It's something where every morning, every evening at by 2:30 today, everybody wanted to know what is happening.
Correct.
So the public is very conscious and aware that a case pertaining to all of us is being heard and disposed of. Now the judges themselves are also particularly human. They are no less human than any of us. They are also affected by what happens, what the public thinks. And this is what determines bail applications in many cases. You see, as far as I can see, a judge probably listens to your prudent media or all other channels. They watch. And whatever comments that are there, even subconsciously affect judgments. Before hearing argument, they read newspapers in the morning. So all what happens there, in some way or the other, also has a effect on the judges.
There is a
mental
wider
condition.
influence.
Yes. So it is not just 436 or 438 or 437 of CRPC which affects, but all these things cumulatively determine whether the accused will get bail or not.
किंवा तुमकां कितें दिसता तूं हे जर दोनी पळयलें म्हळ्यार बेजिकली वाचासुंदर आनी चर्चिल आनी रिजेक्शन, वॉज इट नेसेसरी, इज इट नेसेसरी टू कीप देम इन जुडिशियल लॉकअप? आनीक राघव आफ्तर म्हणटा की दिगंबर बाबान हायकोर्टाक आपल्याली एंटिसिपेटरी बेलाची पिटिशन तयार करपाचें कामां लागपा जाय म्हणटा.
See, this rejection of Churchill's and Vachasundars seem to have serious implications for Digambar. As Radha was saying, most of the reasons for Digambar may be found in Churchill's order. But the two are different. One is a bail application, other is an anticipatory bail application. And as he was saying that the judges also work under pressure and particularly media pressure, but they are trained to be above that. So let us at least presume that the judge has been above the media pressure and he has gone by the records. Now what went into his mind to grant, not to grant bail, we do not know. Maybe after the order is out we will know. But to that extent.
तुमकां कितें दिसता की जेन्ना चर्चिलाची पुलीस कस्टडी जावन जुडिशियल कस्टडी आतां 4 दीस जाले, ताजे उपरांत सुद्दां जेन्ना ताका बेल मेळना, तेन्ना दिगंबर कामत शुड बी रियली वरीड.
Yes, he should be worried because at least I was expecting Churchill to get bail because he is in judicial custody and it makes no sense that he should remain in further custody. Because if he was of some help for the prosecution, that would have been a different matter. But then we do not know what are the reasons the judge has given for denying him bail. And in any case, that may not be subject matter of a TV debate.
Correct.
That would have to go to the High Court.
Correct. अशी परिस्थिती भितर आतां तुमकां कितें दिसता की चर्चिलाची बेल रिजेक्ट जाता, वाचा सुंदराची बेल रिजेक्ट जाता आणि मोहांतीक बेल मेळटा, हू वॉज अरेस्टेड ओनली फॉर नॉन कॉपरेशन, हू इवन सेड की आय हॅड प्रोटेस्टेड अगेन्स्ट दिस प्रॅक्टिस ऑफ करप्शन. As far as Mohanty is concerned, that intention of crime branch to arrest him just solely for non-cooperation, that has got exposed.
No, not necessarily. You see, unfortunately, we do not have exposure to the case papers.
Correct.
We do not know what is investigated, what the judge has read. That only the prosecutor and the judge knows, not even the defense counsel knows.
Correct.
So it is a bit, premature until you have a look at the papers to say why Mohanty was granted. But the fact is, you see, there are always in any
But
drama.
one thing is clear that he was arrested for non-cooperation.
I am not aware of that.
The basic
But-
statement that came from the police was that it is for non-cooperation. He was in know of the entire bribery thing that was going on, and he did not wish to reveal it.
See what happens, in any drama there are principal
Anyway,
actors.
he was the difference is also giver and taker.
Correct.
Now we don't know, as Radha was saying.
See, there is a principal actors. Now here, Digambar and Churchill are the principal actors for two reasons. One is they were the ministers and all, and two is their political force are holding power now. You see, that is very relevant and critical. You see, assuming that the Congress was in power, none of them would have been arrested.
Correct.
That is a factual position. Now the BJP obviously has course to settle, particularly with Digambar. You see, considering the past betrayal, so-called betrayal by Digambar of the BJP, obviously they were looking for an opportunity. So as against Digambar, they are going to come out with all their might, use all their weapons to see that Digambar remains in. This is the way I look at it. And a judge finally, you see, all said and done, judge will go into the vehemence with which the government wants the accused in, the force with which they prove, and all this would go into deciding whether he should get out or not.
ओके, द नेक्स्ट इश्यू जो आसा जो काल जाला, म्हाका दिसता आमी कंटिन्युअसली डिबेट्स करता ती लोकां खातीर
Yeah.
खूब बरी. जे 201 सेक्शन ऍड केला अगेन्स्ट दी जायका सर्वेयर, जाणे ते RTI अंडर इन्फॉर्मेशन दिल्ली, दिगंबर कामतीचेरय केला आणि आर्थुराचेरय केला, विच इज डिस्ट्रक्शन ऑफ एव्हिडन्स ऑर स्क्रीनिंग द एक्यूज. What is in simple terms, what is the charge and how much importance that will play in this anticipatory bail plea and this case?
It may not have much bearing on the anticipatory bail plea, but it is a separate charge under 201 for destroying evidence or for suppressing evidence to screen out a accused. That means to save an accused, you give false evidence. That is a charge. Now that charge can't apply to Digambar. But under 120B conspiracy, that could also be brought against him. And I think that is brought
That
against
is what they have done.
Yes.
They have done.
Otherwise it doesn't apply to him.
Yeah.
But under 120B it would apply.
But जेन्ना आमी म्हणटात की 201, which is destruction of evidence, disappearance of evidence, or as you say in simple words, manipulation of evidence.
So that the accused does not get the punishment he deserves.
दुसरी गजाल जी आर्थूर इज नाव गॉन फॉर एंटिसिपेटरी बेल. आणि एक एलिगेशन अशी आसा, इंटरेस्टिंगली दोन गजाल जाल्यात. एक पुलिसे कडच्यान जी इन्फॉर्मेशन मेळ्ळ्या की त्या RTI एप्लिकेशनाचेर ताणें हातान आनीक क्वेश्चन एड केल्लो
कोणे?
आर्थुरान. आणि सो दॅट इज वन इन्फॉर्मेशन दॅट इज कमिंग फ्रॉम पुलीस. सेकंड, आज क्रायम ब्रांची भितर वतना रिपोर्टरा कडेन आर्थूर उलयला की आपल्याक दिगंबर कामतीनच वचून ते सगळे हाडपाला येयल्ले म्हणून. हाऊ इज दॅट गोइंग टू पॅन आउट नाव? When Arthur is saying Digambar told me to go and get it, police are saying that this is in connivance, any pressure was imposed. And RTI entire form is computer
No,
printed.
but if
and
what
Arthur
you
writes a third
if
question.
you are saying what is correct, then Arthur is only a messenger. He is handing over the application to the police. He is supposed to pick up maybe the response and give it back to him. So he is some sort of a messenger for him.
Correct. दुसरी गजाल तुम्ही हाजेकडे
No,
कशी
no,
पळयता?
on this issue, no.
Yeah.
See, it appears that the police are going overboard. Under RTI, any citizen can move for and get information within 30 days. Now, your officer may grant it within 30 seconds or within 30 days. That is what the law is. Now, in this case, right to information was sought. If I am an accused, don't I have the right to collect all evidence and produce it? More so when the police are trying to say that the document is not available. I have a right to do so. So I am exercising my defense. Where is the question of interfering with evidence, or where is the question of trying to shield anyone?
And finally, that is the officer under the present government.
Yes.
He also knows the entire controversy is over JICA. He is a JICA official.
So on the contrary, I am inclined to believe that the police are pressurizing that officer to withdraw that answer by filing this complaint.
आम्ही डिबेट चालू असतानाच म्हणजे मला डॉक्युमेंट पावला अँड दिस इज द ऑर्डर ऑफ रिजेक्शन फॉर द फर्स्ट टाइम आय एम रीडिंग द मोस्ट इम्पॉर्टंट पॅरेग्राफ यू टेल मी व्हॉट इज द इंटरप्रिटेशन The applicant/accused is allegedly involved in conspiracy which itself is a ground to show that the same is a serious matter and affecting the economy of the state/country. Second thing is there is no material to show that the matter is only due to political vendetta against the accused as there are statements of witnesses who have disclosed of delivery of cash at the residence of the applicant and the company itself admitted its guilt of paying the bribe to the minister in Goa before New Jersey District Court. Similarly, the circumstances existing at present clearly show that it is the collective interest of the community which outweighs the right of the personal liberty of the individual and the contention raised by learner with result. For the reasons stated above, I am not inclined to grant bail to the applicant at this stage. Hence, the order application stands rejected.
That means that the judge goes by the statements under 164
Yes.
for the purpose of rejecting the bail. So he accepts those 164 statements and says that I am convinced at this stage to reject them bail.
So if we consider these grounds, there is no way Digambar Kamath gets anticipatory bail.
Let us look at what the judge will say when it comes to anticipatory bail, because see there is a clear indication. He talks of a minister,
Yes.
and in America also it was a minister. So I don't know. These are various things, as Radha was saying, that only the judge is privy to information. What the investigation has collected, it is between the prosecution and the judge. None of us know that information.
Radha, after reading this, do you feel there is any ray of hope for Digambar Kamath?
Maybe absolutely. I mean, now you see what happens, as
Yeah.
Cleopat has pointed out. The case in American court is very clearly bribe was paid to a minister.
A minister.
The police say, which
Yeah.
I was reading in Churchill's matter, is that bribe was paid to a minister. Now, once a bribe is paid to a minister and a record is available in New Jersey, now the government could have got that record and identified which minister.
Correct.
Now that obviously the fingers point to Churchill because it is one minister. Now if the court finds that it is Churchill, then why should Digambar be kept in? I mean, that is the way I would look at it. When it is one minister, you keep only one in.
Correct.
Now right now the court seems to say it is Churchill. Then Digambar should be out.
So
See, there are no two ministers involved.
So when the order says it is bribe to the minister in Goa,
Yes.
you are
Doesn't say
saying that
bribe to the ministers in Goa.
Correct.
It says to the minister.
Correct.
Now if that is Churchill, then Digambar
court
gets
is-
out.
and-
If it is Digambar, Churchill should get out. That is the way I would look at
and
it.
right now the court is just quoting the company.
No, court is quoting the say of the police.
Say of the
The
police.
police have said that it was the one minister.
The court is saying the company itself has admitted its guilt of paying the bribe to the
The
minister
minister.
in Goa.
Yeah.
The
Minister
minister
in
in
Goa.
Goa.
Yes.
So दूसरी गजाल जी आसा ते very important statement. There is no material to show that the matter is only due to political
No,
vendetta.
that is right. I mean, there would not be enough material at this stage.
Correct.
See what
That part
happens
is-
now.
yeah.
What happens? I don't know.
Because
what is-
see, finally, when it comes to politics, there will not be recorded evidence to produce before the court at this stage. So that the court may be right there.
See what happens. There is no material on to show that there is political vendetta. Means who brings out the case? The state. Now the state will certainly not bring something that is against themselves. You see, at this stage, the accused has no right to produce any evidence. There.
Evidence.
It is what the state brings in. The state only brings in what it suits them. So therefore, obviously, there will be no material there for the court to draw a conclusion that there is vendetta. Nothing of that sort. Will
But
be
that was
there.
a very
But-
that was a very major argument from Digambar Kamath's side.
But the fact is, there has been evidence and a conviction in America. So irrespective of all our arguments, there is an amount of $9,76,000 paid to a minister in Goa.
Correct.
Now, the only thing that I felt was the government should have, before jumping the gun, found out from there who was the minister and arrested him.
Second issue is जो तुम्ही म्हणतात की हांगा मिनिस्टर म्हणा. At the same time, the same order